I'm William Valentin, candidate for COBA President. I'd like to speak to you and clear up a few issues before we continue with regards to my eligibility to run for the President's position. Ever since my announcement to run for COBA President and my intent to do so, I've been met with resistance from COBA. The first thing they told me is that I could not run for COBA President because I was removed from the executive board. What they didn't mention is that the Not-for-Profit Corporation Law, Section 714, has a clause which states that if an executive board member is elected to his position by the membership, then it is only by the membership that he can be removed. I was removed from my position by several executive board members. More than half were not elected to their positions. I was an elected board member, and my accuser, who wrote the charges on me, wasn't even present during my hearing. The COBA did not have a quorum, which is imperative to do any business with the executive board. And furthermore, like I said, there were several board members who were appointed to their positions. Now, I'm an elected official. I'm elected by the membership. It just so happens that one of the individuals that voted for me to be removed from my position several months later wound up filling my position as corresponding secretary. So you see, she had everything to gain with my removal. So I'm fighting that process in court, and that does not apply. Nowhere in the bylaws does it say if you were removed from a position that you cannot run for a position in the next election. That was quickly done away with. The next issue they had is that I was not a current delegate. They state that only a current delegate can run for a position. That's also incorrect. I looked at the bylaws myself. I had my attorneys look at it, and now a Supreme Court judge is looking at it. Basically, it states that you have to have been, past tense, a delegate for at least 2 years prior to the election. I have been a delegate for 14 years prior to the election. The reason for that clause is so that the person running for the executive board will have some sort of experience through COBA. I have 14 years as a delegate and 5 years as a board member for experience. So I believe that that clause also does not apply to me. The third thing they told me was that I needed 25 signatures from delegates in order to be eligible to run. Norman Seabrook then told all the delegates that I was not eligible to run and urged them not to sign my petition, which made it very difficult. However, I was still able to obtain 28 delegate signatures, and I submitted them the other day at the meeting for nominations. At that meeting for nominations, what a fiasco. Norman Seabrook appointed an election committee. The election committee is correction officers just like you. He got to pick who they were, and that election committee was tasked with validating the signatures on the petitions. So validating the signatures. That pretty much gives you the authority to look at the signatures, determine if they were legitimate, see if all the signatures matched. If there was one that didn't look like it matched, you contact the individual. Hey, did you sign this petition? Yes, I signed the petition. Okay, validated. That wasn't the case. Before the election committee even got the petitions, an announcement was made that if anybody had a problem with their petitions, with their signatures, or the validity of the signatures, they should go see the election committee to have them contested. Now, I never heard of anything like that before, but what it told me was that the fix was in. Shortly after that, they began calling delegates into the room little by little, I guess interrogating them. Did you sign this? Did they say that they were running for whatever position, and then they actually allowed delegates to renege and take their signatures back. And guess whose petition had the delegates' signatures removed from it? That would be me. So they took delegates into the room, they coerced them into removing their signatures off of the ballot, off of my petition, and then they claim I didn't have enough signatures on my petition to run. There are no provisions in the bylaws that dictate that I have to tell you what position I'm running for. It merely states that I have to submit a petition bearing the signatures of delegates. It doesn't even say that I have to indicate the position yet. It just merely says that the tally of the signatures, if I have 25, then I'm eligible to run for president. If I have 20, then I'm eligible to run for an executive board position. If I have 10, then I'm able to run for a trustee's position. So why would I write a petition and indicate that I'm running for president before I get signatures? What if I don't get 25 signatures? What if I get 12? What if I get 20? Then I have to alter that petition and it becomes invalid. So I went, I got my petition, I got my signatures in good faith. I was very clear and told everyone that I was running for an executive board position, and I merely needed an opportunity to be placed on the ballot. I told them that I met all the criteria to run for a position, and that I merely needed the opportunity to be placed on the ballot, and that's what they were signing for. I even put a clause in there that said that by signing my petition, you're not indicating that you're going to assist me or even vote for me. You're just merely granting me the opportunity to be placed on the ballot. I don't know how much more fair that could have been. After I received my signatures, and I had 28, I was eligible to run for the president's position. I then attached a cover letter to my petition and submitted both at the nomination hearing. My cover letter just basically indicated I submitted a ballot with 28 delegate signatures on it. That entitles me to run for the position of President of the Union, and that is what I intend to do. This issue is currently in court. I have retained an attorney, and the judge will be ruling on this decision on Monday, May 23rd. So you see, I took the decision away from Norman Seabrook and the election committee, whom I knew were going to object to my eligibility like they've done every step of the way. And I placed it into the competent hands of a Supreme Court judge. That judge will be making that decision Monday the 23rd. So, as far as my eligibility to run for president, it will be decided on Monday. I believe it's going to go in my favor. Once it does, I'll be addressing you again, and I will be campaigning for the position of President of the Union. Together, we can change the direction of correction. I have many, many plans on what to do, and I believe that I have the experience, I have the know-how, and the drive to get it done. But I can't get it done alone. We all have to participate in this. So, I guess I'll be speaking to you after Monday the 23rd. Wish me luck. We're about to change history.